Hello, I'm Chris Burrell, President of the Magic City Bar Association. Thank you so much for joining us for this final installment of our social distancing CLE series. This has been a great year for the Magic City Bar, and it's all because of committed members just like you. At the conclusion of the CLE, be sure to do 3 things. First, submit feedback so you can get credit for attending the CLE. Second, renew your membership. Third, send an email to 5 friends asking them to join or renew as well. Lastly, be sure to join us for our annual meeting later this afternoon so you can be in the know about what's going on with your organization. We will now turn it over to our CLE presenters. Happy holidays.
Greetings, everyone. I am so excited to be here with you all today. I've been told by the powers that be that I have to introduce myself prior to beginning our talk for today. So I'll start with, my name is Ellise Washington, and I am a Birmingham native. I attended Birmingham City Schools from K through 7th grade and Fairfield City Schools from 8th grade through high school graduation. I went on to attend Birmingham Southern College, and then I went to Cumberland School of Law, where I was heavily involved in the Black Law Students Association, which introduced me to the Magic City Bar Association. So I am very excited to be here to discuss the basics of intellectual property law with you all, as we have a discussion on copyrights, trademarks, and patents. So with that, I am going to share my screen to get the PowerPoint started. Oops. Start from the beginning. I think that would help. So in discussing what is intellectual property, I say the initials IP don't only stand for intellectual property, but basically just idea protection. It is the protection of ideas. The origination of intellectual property law in the United States stems from our Constitution. It's in the first article of the Constitution, Section 8, in which it states, Congress shall have the power to promote the progress of science. Hold on, I can't see my thing. Of science, useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writing and discoveries. So what we're going to talk about today, these different, subcategories of intellectual property, which include copyrights, patents, and trademarks. We're going to talk about what is it? What is a copyright? What is a trademark? What qualifies for it? How do you get one? How long can it last? And a few cautions to look for when you're advising someone on intellectual property, okay? So we're going to start with one of my faves, which is copyrights. It is defined as an intellectual property right that's granted by a government, whether that's the United States government or another country's government, because copyrights and intellectual property aren't just in the United States. It's an international theory, and we have these rights that can be secured in various countries. So it's an intellectual property right that's granted by a government to the author of an original literary, dramatic, musical, artistic, or other eligible creative work. The subject matter includes works that are original authorship, they're fixed, in a tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated directly or with the aid of a machine or device. I'm sure you all are wondering why I divided this definition of copyrights into this particular way, because I wanted to kind of go over piece by piece, what are these works, okay? Works of original authorship. What do you think about when you think of original authorship? Authors of books, magazines, producers of movies, etc. These are the types of works that copyrights cover. In addition to websites, those are works that can have copyright protection. They're fixed in a tangible medium of expression. So how are people perceiving or viewing this matter? Is it a tangible book where you can flip the pages? Is this something you're viewing online on screen for this to be reproduced or otherwise communicated to someone? And of course, it says direct or with the aid of a machine or device. So examples include musicals, sculptures, motion pictures, sound recordings, and architectural works. The terms of protection for copyright. So now that we know what copyrights are, what do they protect? How do they protect, and how do these things come about? So a person's copyrights vest, or they come into being at the moment of authorship of creation. So as soon as you think of that song lyric or that sentence to place in your book or anything like that, you have rights to the copyright of that. You do not have to have a copyright registration for your copyrights to exist. So just because you failed to file for a federal copyright for your book or your poem or your movie or your music video does not mean that you don't have certain rights to that. You can still go after someone for utilizing your particular copyright. But if you want to file a lawsuit to protect your copyrights, registration is required for bringing a suit. Okay, so how long do they last? Copyrights are for a fixed amount of time, because what the Constitution told us, it allows those creators, those authors, those inventors to have an exclusive right to their copyrights for a specified amount of time. Now, the specified amount of time, in my opinion, is lengthy, but it's not indefinite. So for an individual author, meaning a person, you or me, a human being, it lasts for your life. So as long as you're living, you have the ability to have your copyrights, plus 70 years. So even when you meet your creator or you pass on, you still have that copyright. It's vested in whatever you've left it with, whether that be in your estate, etc. Those individuals still have a right to the individual who created the work's copyright for a period of 70 years from the time of their death. Okay. Now we know in America and other countries as well, we allow corporations to have copyrights because corporations are ran by people, but they are entities in and of themselves. They operate with their own rules, their own regulations. They make decisions that impact people's lives. So a corporation's term, corporations sometimes they don't die. They can last for hundreds of years, unlike an individual. So what the law has decided is that a corporation has the right to the exclusive use of their copyrights for 95 years from publication, or 120 years from creation. So let's talk about the difference between publication and creation. Creation is what we said. What did we say earlier? As soon as you think that thought, as soon as it comes into being some kind of way, you told someone about it, it's written somewhere, that's not necessarily published, that 120 years from that date is as long as that corporation has exclusive right to use that copyright. As far as a publication goes, to publish a corporate copyright is when it's placed in a tangible format for someone to perceive or reproduce or communicate to another. So once it's published, then you have 95 years from that publication date, but the lesser of. So if you published it around the same time of the time you created it, because it was published, you only have 95 years, not the 120. So as I said, it's not required that one registers a copyright to solidify their rights, but it's important to register for a variety of reasons. One of which is that you can file suit, as I mentioned earlier, and if you are the winning plaintiff, you can be awarded attorney's fees. So those costs that you've utilized, that you've expended to protect your rights, are now available for you to get reimbursed for. You are also eligible for statutory damages. And what the law has maintained this spectrum of statutory damages, they range from $750 to $30,000 per work. So if you have a copyright that's in a medium for your website, or you have also a book, you have a movie, per work, even though it may be around the same subject area, per work, you are still eligible for those statutory damages. And you can get up to $150,000 if you can prove that the person who you're alleging infringed upon your rights did so with willfulness, meaning they committed willful infringement. I'll tell my age a little bit. When I was growing up, we used to use LimeWire. And with LimeWire, sometimes there were sayings on certain things you download that said this is copyrighted matter. But because you were so excited to hear your favorite song or see your favorite video, you click the little download button anyway. So you could potentially have been willfully infringing upon someone else's copyright. And you could have been, fined a lot of money for it. So I know my old technology teacher at Fairfield used to tell us, you guys using that LimeWire, not only you're messing your computers up, you're also doing copyright infringement. I didn't fully appreciate that until I started delving into these matters. So another advantage to registering one's copyright are the customs impounding of infringing goods. So again, you can have a particular subject matter that is placed on a number of mediums, and you can continue to have that be associated with other mediums in which you use your copyright. I know we talked a little bit a moment ago about exclusiveness, the limitations on exclusive rights. So an individual who creates a work, copyrighted work, they do have the right to use it exclusively. But the government did not give them just free reign to that exclusivity. They have placed a great deal of limitations on exclusive rights. So I'm going to pull directly from the United States Copyright Law, Section 107, that says, notwithstanding the exclusive rights section, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. I repeat, it is not an infringement of copyright. So it goes without saying that those individuals who are accused of infringing on another's copyrights, they'll say that, well, fair use. Fair use. I'm going to say this is a fair use of this. I am a teacher trying to tell my students about certain artistic expression. So I wanted to play that in my classroom, and teachers do have a great deal of latitude to do that. Same thing with the news media. We see all the time different excerpts of people's works like books and different movie screens, and people are able to do that because they're reporting on the news. The United States government has said that the public's need to know what's going on around them is a fair use of a copyrighted work. And it's not being used to necessarily make money off another individual's intellectual property, but it is a means to an end. Same thing with parodies and criticisms and comments and things like that. That falls typically under the fair use of a copyrighted work. One that I think is fairly funny and common you would see is parody work. So you wonder how Saturday Night Live, formerly the Chappelle Show, etc., these individuals were not in trouble for constantly making light of people's copyrighted works. It's because of that fair use doctrine there. Also, it stems back to what else is a constitutional right, the freedom of speech. We should not be stymied from discussing things and expressing opinion, making concern if it's purely for that purpose and not of a commercial nature. So let's look at the factors that the court would look at in an infringement lawsuit or a copyright holder would consider when thinking about contacting someone in reference to a potential copyright infringement. One of those would be the purpose and character of the use. All right, was this a commercial use of the person's copyright, which in most cases is highly frowned upon because you shouldn't be able to make money off of someone else's intellectual property, versus a nonprofit purpose, meaning that it's for the greater good. It's being used to assist with helping the community overall. Or is it transformative? Could this be a story that may have some similarities to this copyrighted works, but how this person used it was of such a nature that it transformed the work into something new, something unique, something different? Another factor that's looked at is the nature of the copyrighted work. Is this just a few pieces from a published work? Or is this a literal cut and paste job like Melania did to Michelle Obama when she gave her speech when President Trump was initially elected? The amount taken compared to the whole, less is more. So sometimes it can be difficult to state that a copyright has been infringed upon based on the smallness of the use. Okay, so for example, there is a pretty substantive book over 500 pages, and someone uses maybe 3 similar lines in that work within theirs. That would be something taken into account to say, is this a true copyright infringement? Did it really speak to the full nature of that original work? And last, but certainly not least, is the effect on the potential market for the copyrighted work. Is this preventing the original owner, the intended owner, the person who created this copyright? Is this affecting their ability to monetize their work or to popularize or to make their work known? Is this having a substantial effect on their potential market? So some different portions of copyright that we see firsthand, mostly in the law, are the registrations of the types of authorship. The different types, as I said earlier, are artwork, photography, software, which includes joint works and derivative works, licensing of works, assignments, architectural works, maps, and music. So how would one register these mediums? I know that we have, a wide variety of different media types. You can have a JPEG, you can have a Word doc format, a PDF format, etc., in order for you to register these things. What medium is it in? And how does one go about registering? You go to the U.S. Copyright Office's website, get the application, complete it with specificity, and have it submitted. So that's our primer on copyrights. I do want to move forward to trademarks, which is one of my favorite topics. I love trademarks. So trademarks is an intellectual property type that's granted by the government to an individual, business, or other legal entity that creates and uses a distinctive word, name, symbol, or device to distinguish its products or services from those from any other entity in the marketplace. So before I go forward, let's talk about the difference between what is a trademark and what is a copyright. I know that a lot of attorneys, when I speak with other intellectual property lawyers, one of their things is that when people call them, they'll say, well, I want a copyright for my logo, or I want a trademark for my book. And you have to kind of educate them on, okay, that's all falls under intellectual property. That's something that you created, but the proper terminology for what you're trying to protect as far as your intellectual property goes is that's a trademark, or that's a service mark, or that's a copyright, or truly a patent. I think a lot of people use patent for trademarks or copyrights. So it's important to know what these cover. So as I said, trademarks are a very important intellectual property right because it not only protects the owner of said copyright, but it also protects the consumer because it helps establish brand identity. It's market niche protection. So when you go to McDonald's or a place that has a McDonald's symbol on it, you know you're going to get your favorite Big Mac. It's going to be it may be a little sloppier than other locations, but you're going to get a Big Mac. You're going to get McDonald's fries. You're not going to get a McDowell's burger or fries. McDowell's, for those of you who may not know, is the restaurant in the movie Coming to America. And Mr. McDowell was doing a lot of infringing on people's intellectual property rights. So if you have not seen that movie, I strongly suggest it before the sequel comes out because they are supposedly filming it despite COVID. So trademarks, not only, again, they protect the owner of the trademark, they also protect the consumer, but it also reduces clutter, prevents confusion, and distinguishing things. So if you have if every restaurant was named by their name, wings, how do you distinguish between who to go to for your favorite meal, who to sue if something goes down at that particular place in reference to what they're selling? So it's important to prevent confusion and distinguish things. And it's also relatively inexpensive because we'll talk about this later. You have to register your trademark in order for you to benefit from the protections that it brings, unlike a copyright. So we'll talk about that in a moment, but it is relatively inexpensive in comparison to a patent protection, but it is more expensive than a copyright. So it works well across borders, cultures, and languages so that you can reach a great deal of people. It's long-term protection while in use. There is a short period where you have to continue to renew over a period of years. We'll talk about that in a moment as well, but it does provide long-term protection. It does provide value for expansion beyond your core business. It can be assigned, pledged, and licensed. So the United States government did not limit us from being able to assign our rights away, similar to real property like land. You can assign a real estate contract, same with a trademark. And registration, again, is important and necessary for you to have the level of protection that you're looking for. So the word, name, symbol, device, sounds, and colors, okay? It's used to distinguish your goods and services from those sold by others. And I know that it may sound strange when you all hear that, hold up, a sound can be trademarked? How can a sound be trademarked? I'm going to use, for example, as a point of personal privilege, Ski-Wee is it's trademarked by Alpha Kappa Alpha Sorority Incorporated. Skiwi is so, I guess the USPTO found that it was so closely related to what members of that organization use as their sound that they've granted the sorority the exclusive right to use it by giving them a trademark. Same for your symbols, your names, your phrases, slogans, etc. So I thought this was going to be a little bit more interactive, but I see that it's a webinar. This was my trademark pieces that I kind of showed to my students when we were discussing trademarks in class. And these are partial, these are pieces of trademarks. But I'm sure you all can, because of their notoriety and because you've seen them so much and they're associated with the products or services they're associated with, you can recognize them full on. So these two double O's are Google. Those, like if you add the beginning G and the GLE at the end, that is the trademark for Google. This CO is the beginnings of Coca-Cola. The W is for Microsoft Word. This N is for NFL. And this first arch of a golden arch is McDonald's. These things are so known. We don't even need to see the full logo for us to know whose this is. So it's important that you create something that's so distinctive and you hone it into your brand to protect that. And let's talk about trademarks from weak to strong. How, when people come in, they say, I want to trademark this. And you have to advise them on the ability of that particular word, phrase, image, sound. Is it likely to be registered? And how you assess the weakness or strength of a proposed trademark is looking at whether or not it is unique, looking at whether or not it is already used in association with a particular good or service, and whether it's likely to be looked at. So I just came up with a few little tidbit pieces for people to consider when they're considering whether or not a proposed trademark is likely to be registered. Looking at generic words, so pizza, shoe, those are so generic. It's very, very unlikely that if you're going to try to register a name of a restaurant by the pizza place, it's kind of weak. It's too generic. It also is too restrictive, where it would prevent another pizza restaurant from using that name, and that's what it sells. So I think, utilizing the generic word for something can sometimes be detrimental in your ability to have that brand protection that you're looking for with a trademark. The descriptiveness, does it describe a feature of the goods? How descriptive is it in relation to the good and or service that one is providing? Is it suggestive? Does it require a mental connection? For example, how does one associate a swoosh to Nike? How do you think Nike made the swoosh connected to its brand, its company? How does one do that? So does it require that mental connection for you to kind of associate it with it? One can do that by placing it out into commerce. If you have created a logo or an image or a slogan like the Nike Just Do It. As you all can see, I love Nike. It's my favorite shoe. That's going to be the background for trademarks. But the Nike swoosh and Just Do It. How did they associate that? They put out products in commerce. They put out marketing materials with commercials and radio ads. And there's a whole history behind how Nike kind of revolutionized the branding aspect of athletic gear. So making sure that there's a mental connection between the consumer to that particular product or service. Is it arbitrary? That can actually be good for a strong trademark, the arbitrariness of it. For example, McDonald's for a burger place. That was an arbitrary use of that word. It was like, it's a name that maybe one of the owners was, and it was associated with that. So that's kind of helpful when you have something that's arbitrary. That's not, something that's, you would associate that word with that particular product or service. And again, those things that are fanciful, totally made up, they have a very strong likelihood of being registrable with the United States Patent and Trademark Office. Not that you have to register your trademarks with the USPTO. You can register trademarks with a state. I don't typically advise individuals to register trademarks with just their state, because in today's ever globalized world, you are likely to place this name or this trademark or service mark online where people across the world can view it. And you're going to want protection not only in your home state, but you're going to want protection in every state surrounding you. So it's important that you do that. If you are an international company, then you want to register that trademark with that company's trademark registering office. I highly, highly advise that you do that. So, typical matters when dealing with trademarks. I would say the top 4 are registrations, infringement cases, domain name disputes, and licensing. So registrations, you can, as I said, you can register your trademark with, in the United States, with a state's office, a state's registration office, which is typically the Secretary of State within that particular state, or you can register with the United States and Patent and Trademark Office. Most lawyers will tell you that the USPTO registration is paramount and that it is helpful, and it's not very expensive. Right now, a trademark application with the USPTO ranges in price from $225 for a basic, and then you have $275 for the standard. So how to choose between one, you can consult with a lawyer to decide which of those you select. I would say you select the standard one, which is $275 more expensive, because it gives you an opportunity to, if there's an initial office action, you don't have to refile the entire application. It just gives you greater latitude with being able to make changes. Not saying that the basic does not do the same when you pay the, I think it's the T's plus. It doesn't prevent you from responding to an office action, but it's very limited in those which you can make those changes. And your client will have to pay that registration fee again. So I say, err on the side of caution, pay the additional $50 and register it for $275. But as of January 2nd, 2021, the USPTO is raising its registration prices from $225 and $275 to $300 and $325. You all can go to uspto.gov to hear the rationale behind why they're doing it. The uspto.gov website is very, very helpful to not only the general public, but also to lawyers, because you are able to get updates and things of that nature. If you are an attorney who's looking to get into trademarks, I would suggest watching all of the videos on the USPTO website to learn more about not only trademarks, but patents. But you could also create a free account with the USPTO office so you can register and monitor those trademark applications that you have filed. So that's what I would say about registration. It's not a very onerous task, but the process can be. Before you as a practicing lawyer would file an actual trademark application, I highly, highly suggest you do a comprehensive trademark search, which would entail you searching the USPTO trademark database tests. You can go to uspto.gov to find it, and you can enter keywords, terms, etc., that are related to your particular proposed trademark to ensure that no one else has a pending application for it, meaning that it may not be registered, but it's either published in the Gazette or it's been filed and waiting for an examining officer to release it to the public. But it's important that you do that search for sure on the test search engine on the uspto.gov website. Next, I would say make sure you do a general search like on Google, Bing, Yahoo, social media, so Facebook, Instagram, Google, Twitter, all of these things to make sure that your proposed client's trademark is not used by someone else. Okay, so that you're not infringing upon anyone else's rights. You may have to enter into a brainstorming session to say, because I've done it before, I've looked this up. Someone else has your trademark that you're hoping to use. And it looks like they've been using it longer than you have. So it's not eligible. Let's try to find a way to get this changed for you. But do a comprehensive trademark search before filing a trademark application. That is very, very important. And then you have infringement cases between a variety of people. I would say I've been seeing a lot lately between radio stations, financial institutions, and residential developments, and domain name disputes. So your internet home, your internet address. So www.magiccitybar.org is the MCBA's domain name. I believe we have two now for a variety of reasons, but those domain name disputes can get tricky. And of course, licensing issues where you're the owner or your proposed client is the owner of a trademark. They want to give someone else the license to use said trademark. And suggestions on how to protect. Brainstorm with clients, let them know about the likelihood of registration, deferring strength, whether it's strong or weak, do your full-blown search, register it with the federal government or a state, use it correctly as an indicator, not a noun, use it consistently, with the proper markings. The registered trademark symbol means that the USPTO has officially registered your trademark, and the TM symbol is used when a trademark has not been officially registered, but the person may have a pending application or they're considering filing an application. And then the use or lose, being able to register your trademark. Every 10 years, one must renew their trademark that's been registered with the USPTO. And keep track of other people's uses. I would say make sure that you do a little quick search here or there to make sure that no one else is using it. There are a lot of third-party sites that do that for a cost. So Markify is one that's used to help police the track of others' uses and to do a comprehensive trademark search at the beginning to ensure that the trademark one is seeking to register is not already in use by someone else. And then making sure that you look into your further needs. If you have a state trademark, should you get a USPTO trademark? Should you go for international market? Should you add a tagline and you see that your image is not the only thing you're using anymore? So continuing to reassess your intellectual property in regards to trademarks. And then again, maintain whether it's perpetual, whether it's the 5 to 6 year renewal. Once your application is approved, the USPTO will contact the individual whose information is on record, meaning the attorney of record and or the individual. When an attorney files a trademark application, they also enter the contact information for the registered owner, whether that's a individual or it's a legal entity like an LLC or a corporation, and they will contact the pertinent parties to let them know of a pending renewal date. So it's important to stay on those renewals. That's it for trademarks. So last but certainly not least, we're going to talk about patents this last 10 minutes before we do 10 minutes of Q&A. So I'm hoping to get done with the patent piece in 10 minutes. A patent is an IP right granted by the government to an inventor that gives him or her the exclusive right to the invention for up to 20 years. And it's in exchange for disclosing the details of the new technology to society for its ultimate benefit. So again, a patent is for inventions. And the rationale stems from that Section 8 of Article 1 of the United States Constitution to stimulate the inventive genius and entrepreneurial energy of the common man. So giving an individual the exclusive right to their own invention for a particular point in time not only gives them a monetary benefit when they can be the exclusive owner of that particular invention, but it also helps to push us forward so we can have innovative new machinery, innovative new processes in place for the general public. So the two goals of the US government in creating the patent system were to stimulate invention and to share knowledge, to promote progress in the general welfare by disclosing inventions. And what exactly can you patent? The Patent Act, the United States Patent Act, you all can look it up using whatever, legal search you use. But the pertinent piece that I picked from patent was that it's a machine, manufacture, process, or composition of matter that can be patented if it has the following three characteristics. It's novel, meaning there's a novelty piece. The second portion is the non-obviousness of the particular item or service, or its utility. All three of those work together to know if this is something that's patentable. And the novelty, the non-obviousness, and the utility of said machine, manufacture, process, or composition of matter must be available. You can't just have two or one of these pieces. You must have all three in order for this to be patentable. So the two categories for patentable inventions include products and processes. So a product could be a toothbrush. There was a person who got a patent for a toothbrush, for a Keurig, for a coffee maker. All these different products are patentable inventions. And then you have processes, a particular way of doing things. So agriculture is a big one. So how one does the process for certain agricultural manners, like how to cultivate certain seeds for like pumpkin or corn or whatever. So processes and products are patentable. I know that it's typically understood that products are the only things that can be patented, but no, processes can as well. So when applying for a patent, to practice before the USPTO, you can be a licensed attorney in any state, but to be admitted to the patent bar, there are particular qualifications that one must meet to be met there. But overall, when you're applying for a patent, you must determine the type of patent. Is it a utility? Is it a design or a plant? Determining the filing status. Is it large, small, or a micro entity? And decide whether or not it's a provisional or a non-provisional patent application, the descriptions of which are found on the USPTO.gov website. So patent infringement, just like trademarks and copyrights, individuals infringe upon patents constantly as well. Maybe not so much as a trademark or a copyright, but it's done nonetheless. When a patent is infringed upon, meaning someone has taken use of another's patent, you can demand that the infringer stop and pay damages for past infringement, similar to sending a cease and desist letter. You can offer the opportunity for a royalty, asking them to pay not damages, but they want to continue to use it. You can grant them the ability to use it, give them a license to use or a royalty just by having that royalty agreement. You can ignore the infringement and postpone action until you see where the individual who is using it has done so in a commercial nature, meaning they've made money and you want to be able to get a piece of that pie. Or you could file a patent infringement lawsuit in federal court. Because patents are a creation of federal law, you must file patent lawsuits in federal court. So looking at litigation versus licensing, depending on what the individual wants to do who believes their patent has been infringed upon, is to, if the objective is to stop the competitor from offering the product altogether, then their best bet is to sue. If the common negotiations don't work, to file that lawsuit telling them to not do this anymore, telling them to file an injunction against their use of it. Or if they just want to be paid for it, they're not necessarily upset with the individual for using it, they just want them to pay them the appropriate amount of money to do so, then one could issue a license for the use of that particular patent. And I always say, when advising potential clients on patent issues, because I do work in consortium with a few attorneys who are admitted to the patent bar and do this, we look at who was the infringer. We create a claim chart detailing the product and service that has been infringed upon. We decide venue and then file the claim when there's proof of the use. And a lot of times people tell on themselves nowadays through social media, certain statements that they've made that are easily found. So it's really not that difficult to get proof, but those are our outlook on deciding whether we're going to take a patent claim to court. And you now have what's called the patent assertion entities, where people buy and license patents and responsible business negotiations that provide legitimate benefits. Patent trolls are those individuals who derive settlement revenue from defendants who are willing to settle instead of defending against the suit. So basically they go out and they buy and license patents for just for that particular purpose. They have no willingness to literally have this patent, but they do it for the sole purpose of letting others use it. And there are ways they acquire questionable patents, whether or not this is truly something that they created. That was something that I recently read in, I believe, American Bar Association's recent news article. Once a patent has either been accepted or declined, third parties can challenge patents if they have evidence that an individual has, received a patent incorrectly. So to get at those patent trolls, and they can have it invalidated by the USPTO Patent Trial and Appeal Board. That is a very specific and detailed practice area that a number of attorneys do. I believe that the number of African-American attorneys who practice in this area is quite small per, statistics from the American Bar Association. And again, alternatives to litigations is to do ADR as in any other litigation. Patent disputes are heavily litigious in the cases because attorneys who take on these cases typically just file suit and the court will mandate mandatory mediation. So that is all I have for patents. But if you want to learn more about any of these subject areas I just talked about, the USPTO.gov website is the best place to do it. And I think I hit the time perfectly for the last 10 minutes for Q&A. So I believe that Chris is going to help filter that if anyone has any questions or comments for us today.
Absolutely. Well, Ellise, thank you so much again for your time and for sharing your expertise with us. As you said, I don't know very many African-American patent attorneys, but the ones that I do know, intellectual property attorneys, but the ones that I do know are very, very, very sharp. So whenever I do have a question or a referral, I'm calling Ellise or Nina Spear or one of y'all really smart lawyers who deal with this type of stuff. So thanks again for being here and for sharing your insight with us. We do have a couple of questions, and I want to go ahead and encourage everyone else. We have about 10 minutes, so if anyone else has any questions, please put those in the chat section or in the Q&A. But there's one question that's pending right now. I'll go ahead and ask that. This is from Tanya Scott. Tanya's question is, would the definition of, quote, original works include the compilation of data from various public sources? Examples given were ADPH or WHO, etc.
Oh, yes. So original works, that would include if there was any analysis of this compilation of data. So did someone come up with a correlation between how this data is interpreted? So to say, for example, you have, like I mentioned, the American Bar Association's data on attorneys who practice intellectual property law. If someone wrote a book that discussed that and they said that, well, the correlation between attorneys, African-American attorneys who practice in intellectual property law is low because these individuals tend to have they don't tend to have degrees in those engineering fields or science fields. So there's lesser pool to select from individuals who practice in that particular area. So that could be a way in which a compilation of data from public sources could be an original work. It could be utilized for copyright protection or any other type of works.
Okay, and there's one more question. I guess it's kind of maybe more of a request. Joe Petway wants to know: can we make the handouts available for download?
Yes, we can. I can send that to Chris and he could put it in an e-blast or to the individuals who attended today so that you all can have that PowerPoint. I will most certainly share it. And I also have another handout for IP that I give to potential clients, and it goes over this in very well detailed, I guess, what's the word for it, in a more like a news article, so to speak. It's a brochure, so you can read up on it yourself that way as well.
Okay. And you know what, while we're on that topic, I'll go ahead and take this as a moment to plug another one of the benefits of the Magic City Bar. We have just created a new and updated listserv. So we'll be unveiling that on Monday. That listserv will allow us to be able to refer cases to one another, to share forms, documents, questions, all of that stuff. It'll be a great resource. So I'm going to go ahead and plug that right now. And also I'll use this opportunity for those who are not members of the Magic City Bar or who have not already renewed your membership. Please take a moment to do that between now and the first of the year. I would strongly encourage you to do it after this Zoom call. I think I just saw another question pop up, so let me go there.
I think that was responding to Ms. Petway's questions. I was typing in a response as well.
Okay, all right. Latifa Muhammad asked, how do you advise clients who own historic items? Examples given are a flag, a lapel pin, or historic writings, etc. Copyright or trademark?
So historic items in reference to historic writings of their family member, or can we get some clarification from that? Can she speak, Chris? Can we hear her?
No, unfortunately, we're in webinar mode, so she won't be able to. I'm sorry, what's that, Willie? Latifa Muhammad. All right, well, I was just told by our tech guru / producer, Wayleen Miles, that she can unmute Ms. Muhammad. So Ms. Muhammad, if you are available, we're trying to work on getting you unmuted so that we can get some clarification to your question and at least can provide you a better answer.
Can you hear me?
Yes, how are you?
Okay, hi, Ellise. I'm doing well, and you?
Well.
Yes, I'm, they could be family history or historical artifacts that we know of, like, the George Washington Carver bust that the family owns, his family owns, or Booker T. Washington's bust, or writings that they did. So it could be historic in the nature of, as a people, these are items that have been collected and committed to writing.
Yeah.
Are those, is it copyright or trademark? That's the concern I have. Which of those areas do you pursue?
So typically for those types of matters, for written works from a historical person or a historical time, that would be a copyright. And that luckily does not have to be registered for the most part. If there is no potential suit. And if you do find yourself in a situation where your copyrights have been infringed and you need to file suit, filing for that copyright registration is inexpensive and easy to do. But to protect, I guess, historical writings is more so the most intellectual property that I see here, whereas a flag they created, that could be a trademark. So a flag is, or it could be copyrighted as well, because it is a protected work under those lists of copyrights that we went over. Same for a lapel pin. It's an artistic expression or creation that would be copyrighted. So I would say to look at the ability for it to be protected if the individual who created has passed on. I believe I said early on that a copyright is not, indefinite, it's not forever, but it does have a pretty lengthy amount of time. So it is from the time for an individual, it is for that person's life. And when they pass on 70 years after their time of death, them or the individual's family, their estate, or a entity that they've left the intellectual property rights with, they have 70 years from that person's date to utilize those copyrights to the exclusive use for that particular reason. Does that make sense?
Yes, I follow you exactly. Thank you very much. I appreciate that.
No problem, Ms. Muhammad. Sometimes I talked in circles in my head. My mind is going in so many different directions. So thanks for that clarification. Are there any other questions, Chris? I don't know how to look for them.
Okay, I'm sorry. Let me see. I'm looking right now, and no, I think that's actually all the questions. They have all been answered. I don't see any more. Does anyone else have any other questions at this point? Like I said, if you do, go ahead and throw it in the chat section or in the Q&A. Otherwise, I think we'll go ahead and wrap up. So, I'm sorry. While they're gathering their questions, I want to go ahead and thank Ellise once again for your sharing your time and your expertise with us. We really, really appreciate it. I learned a lot today. I want to again encourage everyone to join or renew your Magic City Bar membership. Also invite others to do the same. Lastly, I want to encourage you to attend our next CLE, which is going to start at 5 o'clock. And that'll be our final CLE for the day. And it's also the very important ethics hour that I know a lot of us are probably lacking. So go ahead and get that ethics credit in. Also, lastly, make sure that you submit feedback after the CLE so that you can get credit with the State Bar for attending virtually. So seeing as how there are no additional questions at this time, I want to thank everyone for joining, for being here. Have a great day. Enjoy the holidays.
I think there was one more question, Chris.
Hello. Oh, actually, no, it wasn't a question. It was just a comment. Ms. Muhammad said thank you.
I think Joe Celeste Petway had one on the Q&A box.
Okay, hello. Oh, I'm sorry. All right. So Joe Celeste Petway's question is, when a person is elderly, can they add a co-author that would extend the copyright time?
Well, I would say if the person is truly a co-author, yes. If the person is truly a person who's added to the creation of this copyright or trademark or whatever, or any other intellectual property matter, that individual can have, if it's a dual partnership, it does to the last surviving individual 70 years from the date of their death. But I would advise against merely when someone becomes elderly, stating that someone is a co-author. The best way to do that is to send a license for that copyright or other intellectual property. License its use to someone else so that, or sell it to that, assign it or license it. I would say assign if you really want to give the full benefits of its use away. Assign the copyright to that person so that that individual can utilize it for their own particular purposes. But it's always with the creator. The creator, when they pass on, they are the individual whose life that you calculate the 70 years from death for. So it's with the original creator. But that's all. Thank you, Ms. Pitway. I thank you for your questions, and thanks everyone for coming to this. I really enjoyed it.
Thanks, everyone. Have a great day.
All right.